Excellent. Hey, good morning, everybody, or good afternoon, rather. We will start here in just a minute to allow some other people to get online with us. Well, good afternoon. I want to welcome everybody that's on the call today, and thank you for joining us. Linkwell Strategies Monthly, we're doing educational seminars that we think will be profitable for the folks that we work with and folks that are considering certain angles of their particular financial situation. This month, I'm very pleased that we get to talk through estate planning with an excellent estate planning attorney that we don't office too terribly far from. We've partnered with a few times, and I'm very excited for him to share with you today. So here at Linkwell Strategies, we are a financial planning firm that does investment management alongside of excellent CPA and enrolled agent partners who look at the tax side of things as we look at the financial planning side of things, trying to be the most tax efficient as we can as we lay out a great retirement for those that we work for. So today, our hope is that you would learn what you might need and take from this certain pieces that apply to your situation and follow up as you have need to schedule time with Rick, schedule time with us to talk about your particular situation. That in mind, there likely are going to be a number of questions, and there will be a Q&A portion here at the end of our time today. I might just mention that one of the things about questions to CPAs or financial advisors or to enrolled agents is that oftentimes the answer to those questions is it depends. It depends on your unique circumstances and your unique situation. Unfortunately, this format doesn't accommodate for that. So if we do receive a question you've asked, we will take it offline and make sure that it does get answered for you, just so you know. Today, I have the pleasure of introducing to you Rick Smith. Rick was born in Indiana, but raised in Dallas, Texas, and moved his family here in 2013 and transferred law schools and graduated from Washburn Law. He's raising his family here. He is an estate planning attorney licensed in the state of Kansas, and I'm very glad to have him with us today. So Rick, thank you for being with us. I'm going to pass it on to you and let you teach us today.
Okay, sounds good. Thank you, Kyle. And it has been a pleasure to work with Kyle in his office. I'm going to defer a few things in my presentation to them as the experts. But today I hope to introduce you to a few things. I just want to start out by acknowledging sort of the blessing and curse of having technology like this. If there's one thing that I enjoy most about being an attorney, it's educating people, teaching about how the law works and sort of seeing that light bulb moment come on. I'm not going to have that privilege today to see the light bulb moment go on for you, but I hope it does. And as Kyle said, if you have questions, you can put them through. And, you know, this is kind of a general, I echo what he said about the sort of the it depends answer. I'm going to be talking general information. This is educational, but my job is to meet one-on-one with people and explain things that apply to their specific circumstance. So if you have questions, I'm happy to meet with you. At the end of the presentation, I will have a slide that has my contact information, including website and phone number and email. You're welcome to jot that down when we get to that point and reach out to me, or reach out to Kyle Johnson's office and they can put you in touch with me. Maybe let me pull up the slides here that I've got, and then make sure that the screen is sharing properly. This is the magic moment where we see if this works properly. And I was running through this, so I'm at the very end. Let me go all the way back to the beginning. Here we are. Well, Kyle, I appreciate the introduction. And I guess maybe just by way of further introduction, I have 2 sons and 4 daughters. My wife and I have 6 kids. We met as artists in college and quickly realized that a career in art would not support a family unless I got really good at figuring out a successful way to do that. So I pivoted and taught for a little while, and then went into came to law school, and I've enjoyed. I think that I said this already, but the thing I enjoy the most is working one-on-one with people. My undergraduate studies was in interpersonal communications, and like I said, I had a teaching opportunity for a while. So this is kind of my bread and butter. And also to reiterate, I am licensed only in Kansas. So what I'm talking about today is Kansas law. If many states have similar laws with respect to probate and estate planning, but this is Kansas specific. My practice focuses primarily on probate. Now, probate is not a word that we use a lot. And so I hear it get confused with a number of different things. So by way of definition, probate is specifically working with inheritance law, with wills or estates where there is no will, last will and testament. Under the probate code is also adoption and guardianship work. And at first I was a little confused by that. Why would these go under the probate code rather than family law code, for example? But I have come to realize that the procedures and the purposes are very much the same. In essence, trying to protect those that can't speak for themselves, whether they be deceased or a minor child or incapacitated in some way. So I've had the privilege of working with some adoption cases, quite a few guardianship cases for adults and children, and have really enjoyed that. And then the other side of the probate coin is the estate planning, putting together wills and trusts. That's really where I started in this industry, and then got into the court work, and I really enjoyed both sides of it. Today I'm going to go over probably some of the most common questions I hear, and I could easily say I have heard these questions hundreds of times. I talk with families who are trying to plan ahead or dealing with the death of a loved one, and these tend to be some of the top questions I get. So I'm hoping that this is helpful to you if you have asked or have wanted to find the answer to any of these questions. The first is, what is involved in an estate plan? I'll touch on that briefly here at the beginning. Second, what is probate and when is it necessary? Which is better, a will or a trust? Are there alternatives to a will or a trust? And probably most commonly, how can I make things simple for my family? I'm going to sort of fast forward to the end of my presentation for a minute and park on that last question. Most of the phone calls I get are from folks that have already been dealing with kind of a messy situation, either through probate or trust administration, or just some sort of situation with property after somebody passes away. And the number one thing I hear is, how can I make things simpler for my kids so they don't have to deal with this? If there's one thing I hope you take away from my presentation today, because I'm not going to be able to cover everything, I hope that you walk away with, I guess, this concept. If you want to make things simple for your family, you've got to understand how these different pieces fit together, how probate works, how a will works, and what it does and what it doesn't do. Because I see a lot of misconceptions, and I think that if you understand how these things fit together, you can make a more informed plan, even if it's a very simple, basic plan. So I will touch on that throughout and at the end, but I just wanted to sort of start with that. Well, let's talk about what the term estate planning means. We use that term fairly loosely in the industry. Obviously, dealing with an estate refers to the property that you own when you die. But an estate plan can involve a lot more than that. For example, powers of attorney regarding healthcare decisions or financial decisions during your lifetime. Those are what I consider sort of the living plan, the things that you need to put together in case you reach incapacity or unable to manage your own affairs due to an accident or something else like that. Also, a living will declaration is commonly known as an advanced healthcare directive. So you can put down instructions for end-of-life care and things like that. There are a lot of different pieces, but these are kind of the main pieces of an estate plan. Now I'm going to talk more about trusts and wills. But before we get into specifics about different kinds of documents and plans, I think it's important to emphasize that any sort of estate planning really has two main objectives. You can do a lot of fancy stuff, but the bottom line is the most important questions are, who do you want to inherit your property, and who do you want to help with that process of getting things distributed to whoever is entitled to them. So for example, in a will, you can name, pardon me, you can name beneficiaries under a will. There's special terms for those, but sort of the blanket term I'm going to use is beneficiaries. And then you can name in your will who's going to be the executor, who's going to be a trustee under a trust agreement, or in the case of minor children, who's going to be a guardian. So for example, my wife and I have some documents together. We have put in all of these things in there so that if something happens to both of us, then things are organized and taken care of. In general, here are some reasons that folks might want to put together an estate plan. Obviously, we talked about the idea of providing for surviving family members, including directing what happens with the care of minor children. I touched base briefly on accidents and incapacity, but also there are things that I get quite a few questions about: long-term care, Medicaid planning, other tax incentives. I don't get a ton of tax questions, but when I do, I refer them out to tax experts like Kyle's team and the experts that work with Kyle's team. And just, I know I said this already, but I am not a financial planner or a tax expert. So I'm going to touch from the legal side and leave that to the other experts. The long-term care and the Medicaid is another sort of niche area. I bump into Medicaid quite a bit, and you may be familiar with the fact that, if someone receives care paid for by the state, such as through Medicaid or CanCare, the state has a claim, or can file a claim on that person's estate. So with every probate estate I'm filing, I'm providing notice to the estate recovery unit of the state and work with them on either negotiating a settlement or seeing if they file a claim at all. Sometimes they choose not to, such as in the case of a minor child, but there are a number of things that can go into planning for that. I do some of that, but not all. And then these things are at the bottom: the simplicity, family harmony, privacy, and reduced costs, all kind of relate to the same thing. And that is, if you've got a complicated situation or a situation where family members don't get along, it can get very costly. And probate, by definition, is public, which I'll touch on a little bit more. But these are just some ideas of why folks want to put together an estate plan. As you can see, there are quite a few reasons, and not all of them will apply to every person. So you might have one or two reasons, and the next person has some others, which is another reason why understanding how these pieces fit together is necessary to create your plan. So let's talk on a basic level: what is probate and when is it necessary? Probate is the court process for transferring property that remains in a deceased person's name. And another common question I get is, well, if I have a will, then doesn't my estate avoid probate? And the answer is no. A will is a probate document. In fact, the full name of we call it a will by short, but the full name is a last will, meaning the most recent, and testament, a last will and testament. That testament part means this person who put their will together testified in front of two witnesses, which is required by Kansas law, and a notary is recommended. But the idea is this is an out-of-court sworn statement that gets put into writing that is intended to be submitted to a court. So a will is a probate document or a court document prepared in advance. I'm going to talk a little bit about, I guess, why probate would be necessary. And to do that, I'm going to illustrate using myself as an example. So like many of you, I own different kinds of property. I have some bank accounts, I have a home, and some vehicles. Let's just assume that my car that I use to get to work every day has my name on the title and not my wife's name. But let's also assume that on the title, I have a transfer on death beneficiary listed. Let's say I have my wife listed as the transfer on death beneficiary. Now, I'm going to pause for a moment. Many people are not aware of this. I wish that it was advertised at the Division of Vehicles downtown, but it's not, as far as I have seen. Anybody can put a beneficiary on their vehicle title, and you can request a new title, or if you buy another vehicle, at the time you're getting the title, just ask for a beneficiary to be listed. So anyway, for this example, let's assume my wife is the beneficiary. And then let's say I die, that vehicle or the title of that vehicle can automatically be transferred to my wife. No court process is necessary. It's not subject to the directions in my will. It happens out of probate automatically. All she would need to do is provide the death certificate or other proper documentation to the Division of Vehicles, and the title can be switched over into her name. By way of another example, let's say my home is owned jointly between the two of us, which in our case it is, or at least when we bought our home, we bought it jointly. Now this can be separate from the loan. That's kind of a different question, but let's say on the deed, it has my name and my wife's name, and then the magic language as joint tenants with right of survivorship. That language has to be in there in order for this to happen. But if I were to die, my wife would automatically be the surviving joint owner of our house. She wouldn't have to go through probate. It would automatically be in her name. Well, when I say automatically, I mean she provides a death certificate to the Register of Deeds. They take my name off, and it's done. No lengthy court procedure. But let's say for this example, I had a bank account that was in just my name, and when I die, that bank account cannot be transferred except through a court process. Now, there's one exception to that. If the entire estate is less than $40,000 and doesn't include real estate, then there's a way to do that without probate court. But in most cases, we're talking about a court proceeding to transfer any assets that were stuck in the deceased person's name. I'll come back to that illustration in a minute, but I just wanted to give kind of a general overview of the probate process, because I get a lot of questions about how long it takes and sort of what the process is. Probate for any asset that is stuck in the deceased person's name begins with a petition, which is a document that's filed with the court and has to contain certain things, certain information to let the judge know that information about the person who died, what property we're talking about, and whether there was a will and things like that. Once that gets filed with the court, a hearing date is set, and then the petitioner, the person who asks the court to open the probate proceedings, has to send notice to all the family members and creditors that are known. And it's a little more nuanced than that, but generally we're talking surviving spouse and children. And if there are no surviving spouse and children, then we go out from there. But that notice is provided to make sure that everyone's on the same page, that no one is left out, that if anyone has another copy of a will that we didn't know about, they're on notice that, hey, now's the time to come forward and make things known to the judge. At that hearing, an executor or administrator is appointed. So if there was a will, an executor who's named in a will is appointed, unless the executor says, no, I don't want to be the executor. A lot of times, I'm going to pause here for a minute. A lot of times the executor thinks that they can just take the will and start doing things. And the truth is they do. An executor, the nominated executor, has no authority until this hearing, until they're appointed by the court. So the person who's named in the will has to choose, am I going to do this? Am I not? Thankfully, due to some amendments to the Constitution, we don't have slavery anymore. So no one is required to be an executor administrator, even though I think a lot of times they feel an obligation to do so. But I get a lot of questions about how that works and what it's like to be an administrator. That's kind of a separate conversation, but I'm happy to answer questions if there are any. As for, excuse me, then we get to really the bulk of a probate case, which is the administration portion. After the administrator is appointed, then it's getting to work. It's gathering assets, it's gathering information, because the administrator is going to be the one who has the court authority to call the bank and gather information, or to change the title to the vehicle and sell the house and things like that. And then at the very end is the final settlement, which essentially is the accounting to the court. The executor or administrator provides information to the court. I failed to mention that if there was no will or no executor named in a will, or if the named executor chooses not to serve, the court will appoint an independent administrator, or one that's recommended by the petitioner. But at the very end, the administrator is required to submit a number of things to the court, including an accounting of all the ins and outs of the estate, and then get the final approval to distribute the remaining assets to the heirs or beneficiaries. So that's kind of a quick overview. This overview is much faster than, of course, it goes in real life, which is typically 6 to 9 months. It can be shorter, depending on the situation. And I've been involved in cases that have gone much longer, well over a year. And there are many cases that I've not been a part of that have gone much longer than that, and I'm glad to not be a part of those. But that's the general overview. So there are ups and downs to probate. As a probate attorney and an estate planning attorney, I have developed a healthy respect for this process. And when I say healthy respect, I guess I mean I recognize that the court supervision is sometimes really important to make sure that things are done right, that nobody's hiding stuff or taking off with property that they shouldn't. And so it's by design very thorough, and it's a public record. But of course, those are the downsides, that it is court supervised, thorough, and public, which means it can be costly and time consuming and wide open. There's quite a bit of information that goes into the probate documents that goes on public record, which is one of the reasons that some people prefer to use a revocable trust or some form of a trust or some other transfers. So I'm going to get into some of those different methods of transferring property at death, and hopefully this is helpful. But just to recap, probate is necessary when any asset is stuck in a deceased person's name. Let's go to some of these methods of how to avoid probate. I'm going to start with trusts and then talk about some of the others. I've already kind of shown you some examples, but I think trusts are the one that I get the most question about. So let's talk about what is better, a will or a trust. And as Kyle indicated, the true answer here is it depends on your situation. Here's a kind of a side-by-side comparison of how wills work and how trusts work. A will, as I mentioned, is a court document, requires probate procedure. The person named as the fiduciary there is called an executor. And in a will is typically where we see a nomination for somebody to serve as a guardian for minor children. The reason we see that in a will typically is as I mentioned at the beginning, probate court has jurisdiction over guardianships. In Kansas, at least under Kansas law, there's no way to appoint a guardian outside of court. It requires a court procedure because, I guess, as a matter of public policy, we want to make sure that children are taken care of properly. And so there's not a, I have seen forms that people have tried to present to me saying, this is a guardianship paper. Kansas statutes doesn't allow a sort of delegation of parental authority. I think there are some states that allow you to do that under sort of a power of attorney, but not as far as I've been able to see in Kansas, even though I see it on websites out there, including some Kansas website businesses that run in Kansas. So anyway, I got off on a tangent there, but let's go back to trust. So by comparison, a trust does not require court supervision. This is one of the, I guess you could say, main benefits and drawbacks. It's called a trust for a reason. You really have to trust the person who's appointed, which is the trustee. And by naming a trustee, you are essentially giving them the keys when the time is right for them to manage your property, your estate, including after you pass away. And part of the reason it's called a living trust, if you've heard the term a living trust, that's referring to the fact that it's set up while you're living. Some trusts are set up at death. If there's a will that says I want a trust to be established, and then that's an at death trust or a testamentary trust. But a living trust is set up where you essentially create an agreement or declaration that all of your assets will be held in trust for the benefit of the beneficiaries. I've put an illustration of a little box there for a reason. This is my best way to describe or illustrate what a trust is. It's kind of like a box. So imagine you have this box in your hands and you say, okay, I'm going to put my house, I'm going to own my house in my trust, and you sign a deed transferring the property to your trust. You can put your vehicle in there if you want, although there are several reasons, I think, to leave a vehicle out of a trust. You can put bank accounts in there by going to the bank and providing trust documents, and they add the trust as an owner or transfer the assets to your trust. So by way of illustration, you can hold all these assets in your trust while you're living. And a lot of folks choose to be their own trustees during their lifetime. In fact, I'd say 9 times out of 10, the standard revocable living trust is where, in fact, by way of illustration, my wife and I set it up this way. We are trustees of our own trust. We deeded our house over to our trust. So if you try to search for my name on county records, you're not going to find me on property records because our house is in the name of our trust, and a number of different things we have put into our trust. Now, we haven't put everything in there, and that's by design. That's particular to our circumstance. We decided not to. But these are the types of things that you can do. I'm going to give you a little more illustration of that later, but let's talk about some other methods just so you can kind of get a handle of how these work. So these were some that I mentioned earlier, although I didn't mention gifts or sale. Now, with respect to any of these, there are potentially tax implications. For example, gifts and sale can trigger certain types of tax events. So you want to be careful that you get good advice before giving away all your property to make your estate planning easier. But just to make sure that I cover, I guess, all the different options or several of the options, you can, if you give something away or you sell it before you pass away, then of course that's not going to be part of your probate estate or your trust. And you can apply these in any way. So you could own your house jointly. You could own your vehicles jointly. You could give a vehicle away, give a house away, sell it. I hope that makes sense, that any of these methods can be applied to any of the different types of property that we own. And all of these will avoid the probate process. And so that's what I'm trying to illustrate, that these transfers happen outside of probate and really outside of a trust. Let's look at the trust illustration one more time. I mentioned that my wife and I set up a trust. In fact, we set it up years ago, and then I changed it a little bit and we renamed it and went back to the bank and got things fixed. But essentially we have tried to put all of our assets that we want to be held in trust into that box, so that if something happens to both of us, our named successor trustee can step in and manage things for our kids and whatnot. There would still need to be potentially need to be a guardianship proceeding for certain purposes, but in terms of managing our finances and property, it would all be taken care of fairly quickly. So in summary, here and sort of side by side, here are the alternatives that I see to a will and to a trust. And I put them in this order for a reason. So from left to right, when I get a phone call on a probate estate, I get a phone call from someone saying, hey, I need to figure out whether probate is necessary or what I need to do to get this taken care of. I will ask for a list of assets to the best of their knowledge, and then I go through those assets one at a time, and I go through this order. I say, okay, was this given away or sold within a certain period of time before they passed away? And most of the time that's not going to come in, but there are some circumstances where it can. Secondly, I'm going to try to find out, was there a joint owner? Is there a surviving joint owner? Does somebody else still own the property? Number three, was there a beneficiary listed? Life insurance or other retirement assets are good examples of this. I'm sure you've heard from a number of different professionals that updating your beneficiaries. Have you updated your beneficiaries? This is absolutely crucial, because the law presumes that if you have someone named as your beneficiary, that's what you mean, and your will does not control and cannot change the beneficiaries listed. There are very few exceptions to the transfers to the beneficiaries as named. And like I said, you can put a pay on death or a transfer on death designation on just about any kind of property under Kansas law. And that's kind of nice. There are some states that don't allow that for real estate and other assets, but in Kansas we can. And then of course, lastly, as we talked about, this trust idea that everything can go, you can essentially take care of the probate process now ahead of time by putting everything in a box and saying, no thanks, judge, we don't need your help. We have everything buttoned up and ready to go, and I fully trust this person. And then probate is the process of sort of the catch-all for anything that was there, whether there's a will or not. I hope that makes sense. This is kind of the process I go through. This is the process I go through with clients. And so that kind of takes us to this final question: how can I make things simple for my family? Well, as I said at the beginning, in my opinion, the most important thing anybody can do to make things simple for their family is to first understand how these pieces work, how a will works, what it does, what it doesn't do, how these other transfers might affect certain assets. And once you understand these and can sort of think through them specifically with respect to your own property, then of course, and this is what I do with clients, I'll ask for a kind of a brief inventory, and then we go through assets one by one, and I say, which of these do you think makes the most sense for your house or for your vehicles or for XYZ? And we go through assets one by one and come up with a plan that makes sense. And then lastly, of course, you actually have to make those changes. If you're gonna make changes to beneficiaries, you got to actually do it. There's no going back and changing it after you pass away. So it really, I've seen situations where forms are all filled out and they weren't signed and submitted to the company, so the beneficiaries were never changed. And I can't change it. Neither can the judge, except in some very limited circumstances. So I hope that's helpful as an overview. Now, some of you may be thinking, well, this seems like a lot of work to try to understand this and whatnot. And I would say, you're right. It is kind of a lot of work. So the simplest thing that you can do for yourself, if you don't want to go through this kind of planning, is do nothing. And then you can rely on the default laws of the state, which is fine. I have some folks that prefer that, or they prefer to just put together a will and let everything be handled through the probate process. But in some ways you kind of have to decide, is it going to be simple for you or simple for those who survive you? That's an overgeneralization, but I usually present that question when I'm talking with clients, because I do have some that say, I want to do it simple for me. And I say, okay, that's fine. One thing I do want to clarify is that there's sort of a misconception that if you don't have a will, that the state is going to come in and take your property, or the IRS is going to take everything, or whatever. That is not really true. And I think that misconception to some degree is the fault of attorneys in this industry. And so I feel some obligation to kind of correct that misunderstanding. As I mentioned earlier, there are times when the government can come in and file a claim, such as if Medicaid or if assistance was paid for by the state, or there are taxes that weren't paid, or things like that. Of course, they're going to be able to file a claim, but that's no different whether you have a will or not. In fact, it's no different whether you have a revocable living trust or not, or even some irrevocable trust can still be accessed by the government in that way. So anyway, I'm getting a little bit into the weeds, but I just wanted to clarify that because I hear that a lot, and I just think it's a tragedy if everyone's afraid of the government if they don't have a will, and that's not exactly accurate. So that's it for sort of the general overview. As it was mentioned at the beginning, if you have questions, I'm happy to touch base on some questions, but feel free to jot down my information if you want to reach out with specific questions or want to schedule something. As Kyle indicated, I'm not too far from their office, and I'm happy to meet in their office. I've met with clients in their office before, or we can meet over here in my office. It's been a pleasure to work with them, and I guess, Kendall, I'll pass it back to you.
Awesome. Yeah. Thank you so much for sharing. Yeah, we really appreciate it. So we're going to move into a time of a few questions and answers here quickly. So if you have a question that's on your mind, go ahead and put that in the Q&A box at the bottom of your Zoom screen there. I have a couple that we'll go ahead and get started with, and then we'll answer any that may come in. So first question is, how much does probate cost?
Good question, and that's one that I hear a lot. I'm going to start with it depends, because it really does, but I know generally people want to understand, okay, what does this look like? Normally I tell people, if this is a fairly standard procedure, it's probably going to be between $5,000 and $7,000, and that includes attorney fees, court filing fee, the publication, news publication, typically a notice has to go into a newspaper, especially when real estate is involved, and so the cost for publishing that for a few weeks, and then there are incidental costs, including administrator fees and other things. All in all, I think a fairly safe estimate is to say an estate could cost $10,000 in total administrative costs, including attorney and probate fees. So that there are some proceedings that can be done a lot simpler. For example, I think I mentioned at the beginning, if there is less than $40,000 in an estate and no real estate is involved, sometimes I can put together a simple affidavit to have bank accounts or something else transferred over without a court process, and that's usually just a few $100s. I mean, if it's just one asset, one beneficiary, or just a few, and they're all on the same page, I would probably say that the biggest factor in the cost of probate, at least from my perspective, is how well people get along in an estate. And unfortunately, there are circumstances where people are filing defenses or objections that are, I guess, less than valid, and it's just a matter of family disharmony, and that's always really hard to see, because and a lot of times I will propose to families, if I can see that coming, I'll propose, hey, let's get in the same room and have a conversation, even if there are other attorneys that have to get involved. Let's get a settlement agreement in place. Let's agree to sort of some ground rules of how we're going to divide this up if there's any question or confusion, in the hopes of preserving more of the estate assets for the people who would be inheriting from it. So anyway, sorry, that was kind of a long-winded answer to your question, but yeah, it can be kind of pricey, which is why some people would rather avoid that.
Yeah, absolutely. That's certainly encouragement to get some of this in order beforehand. So yeah. Next question here. Is a living will the same thing as the wills that you were talking about?
So I live, and I hear this a lot. And I wish that I could change the terminology, but I'm not the legislature, so it is what it is for now. A living will is different from a last will and testament. Now, I've been using the term will very loosely, referring to a last will and testament, meaning the document that you sign saying after I die, I'd like my property to be distributed as follows. Now, a living will, the proper term for that is a living will declaration. The key word on declaration, which is well, and living. It's a living declaration of what you want to have happen to you during end of life care. So, for example, there have been some cases where people have been on life support, and I'm going back in the past quite a ways into some different states, but some of you may be familiar with, I believe it's the Terry Schiavo case from quite a ways back, but there are cases where people have been on life support and the law does not specify who has the authority to decide what happens to their care or whether they remain on life support. Anyway, that's sort of where living will declarations or advance directives came into being. Kansas law allows us as individuals to declare what we want to have happen to us in terms of end of life care, life sustaining support, things like that. It's a very short document typically, but I will say of all the documents I put together, it's probably the one that I get the most pause on from clients and the most sort of let's go back and forth and change the language or things like that, just because this is a very personal decision and obviously one that holds a lot of gravity. So great question. Yeah, a living will declaration is different than a last will and testament. To make things even more confusing, we have the term living trust, which is more like a will to some extent. So like I said, if I could change the terminology, I would, but I'm afraid it is what it is.
Yeah, that makes it. There are a lot of layers of that. A lot of those that sound very similar. So that's helpful. I appreciate your answer there. All right, last, we have time for one more question here. It's a little bit of a two-parter. So this question is, can multiple executors be named in the will? And then does an executor need to have any specific skills or knowledge?
Great question. So that is I've dealt with co-executors in a will. So the short answer is yes, you can nominate multiple people. You can nominate, I don't know of anything, and I may be missing something here. So if I had this question, I would go back to the statutes to verify, but I think you could nominate 10 people if you wanted. But the idea that I've seen and the problem that I've seen is when you get too many cooks in the kitchen, it can be really difficult. I guess there are a whole bag of issues that I can see with co-executors. I think a lot of times, and I've done this for clients where if they insist they want to have two people named, I will do it because the idea is to provide some sort of security of knowing that, hey, there's accountability between the two of them. But by definition, an executor is somebody who's going to be appointed by the court and have a lot of supervision anyway. And so I can see a co-trustee situation making a lot more sense than a co-executor situation. I think my very first probate case was one where there were two executors named. They didn't know each other very well. They weren't related to each other, and they didn't trust each other. And it was a nightmare of a case that was very expensive. The judge was unhappy with everybody involved. And quite frankly, as a new attorney, it scared me to death because there were just so many issues going on. So that has sort of scared me away from putting that into too many wills unless I talk through the sort of risks with clients and they insist that they want it to be done. I guess I will also say I have seen good situations where it's worked out okay, but the nice thing about it, naming it as an executor is you could even say this person or this person, whoever is, most available or whoever they agree between them. Ultimately, the judge is going to appoint whoever is willing and able, but the judge has to follow the recommendation as included in the will before the judge goes to anyone else who says, yeah, I'll do it, if that makes sense. And if no one's listed in the will, anybody can essentially say, I'd like to be the administrator, but there is kind of an order of who the judge is going to look at first. And then
Yep.
there was a second part to the question. I don't know if I answered it. What was it again?
Oh, sure. Yeah. Do executors need any specific skills or knowledge?
Also a good question. So short answer is not really, but practically speaking, it's helpful if the person at least is, well, let me answer it by saying an administrator's duty is going to be, an executor or an administrator is going to have to gather the assets, create an inventory, work with the attorney, and a lot of my clients, in fact, I'd probably say most of the time I'm representing an executor or an administrator in probate cases, and my job is to teach them what they need to know. So they don't really need the specialized knowledge. I'm drafting the documents that include all the things that are required. I'm submitting those to the court, telling them when the deadlines are, all those kinds of things. In some ways, I compare what I do to mechanic work, like working on a vehicle. There are a lot of different pieces to the engine, and my job is to know what they do and how they work and when they need to fit together and whatnot. But the administrator's job is to drive the car, to go out and actually gather the information, the assets, and to take care of things. But you don't have to know how the engine works in order to drive the car. The one thing I would say is the administrator or the executor has to be someone who can keep good records and can communicate well with people. So I think those are fairly basic things that most of the time, if you're named as an executor in a will, it's because you're probably the person that mom or dad or whoever wanted, they trusted you to be savvy enough to do that. So yeah, I hope that answers the question.
Yeah, that's really helpful. And it makes, thinking about potentially being an executor of someone's trust, maybe a little less daunting, that you will have a lot of help along the way, as long as you can keep yourself organized and and communicate well with everyone involved. So that's very helpful.
Can I add one more thing to that?
Yeah, absolutely. Go for it.
I will also say that the administrator or executor is kind of the centerpiece with working with a number of professionals, not just the attorney, but working with financial planners who have information about assets, for example, like with your office.
Absolutely.
As well as with tax professionals, because an administrator and executor will be required to sign and file tax returns for the deceased person and their estate potentially. And there are a number of different types of tax returns, but most often it's a fairly basic return that gets filed. And anyway, that's part of the job, is to make sure all those things get buttoned up. And so working with all the different professionals and making sure things get done. And one thing that I think is important for everyone getting into that to understand is that the estate will pay the administrator typically for their time and their out-of-pocket expenses. So this isn't a gratuitous service. It can be, but I always tell administrators or executors, keep track of your time, even if you're not gonna if you don't think you're going to build the estate, because you might change your mind 6 months from now.
Awesome. Hey, well, Rick, thank you so much for joining us today. We appreciate all of your knowledge and expertise on this topic. Thanks everyone for joining us today. Our next monthly webinar will be at noon on Wednesday, October 4th, and we'll be discussing small businesses. If you have any questions about anything that was discussed today, feel free to reach out to Rick or reach out to our office, and we'd be happy to point you in the right direction or answer any more specific questions about your specific scenario in your life. So once again, thanks for joining us today, and we'll see you next month.
Take care.